week we talked about how to avoid going to court, mainly making sure your communications were crystal clear, that you talk whenever possible instead of writing things out, especially with texts and emails and that sort of stuff, being reasonable, and having everybody's expectations be where they should be. So today I'm going to talk about how to win in court. Here's the legal disclaimer. I am not a lawyer. You will get very different advice from lawyers, and certainly different advice from all of the wannabe lawyers that you see online. I'm only going to tell you what's worked for me. And truly, 62 years old, I've been in court a few times over a few different issues, and I've had some legal actions threatened against me. Years ago, Major League Baseball tried to take me on for using the clip that I have in the 1% Solution Volume 1, and I took them on, and I won. Because I was right and they were wrong. And that's ultimately the best defense. Be right. And if you're wrong, admit it, and you don't have to go to court. Don't be a jerk about it. So here's how you win in court. It's a couple of really simple steps. The first thing is you have to be reasonable. You have to make sure that what you're saying is true and accurate. So start by being very reasonable. Second, if you go to court on a contract case, because that's what it's going to be probably. It could be a liability case, I suppose, but either way, if you go to court, you are going to almost certainly be in small claims court, and every state's different. We're in California. I think the limit has now been raised. It used to be like 3,000, it went to 5, and somebody told me it went up to like 8,000 now. I'm not sure if that's true, but it's a small amount. That's what you're going to probably be sued for, is a small amount. It's going to be small claims court. And while the judges in small claims court do have to follow the law, there's a lot of ambiguity, and what they really try to do is to make things right. And the way you make things right is you make sure that you figure out quickly who is the victim and who is the villain. And clients will always try to paint themselves as the victim. It's important that you show yourself to be the victim. You're the one with the loss. I'll give you a couple of examples of that. In your contract, crystal clear. So the biggest issue we all face is this. You get a non-refundable deposit. We'll talk about the word deposit in a second. You get a non-refundable deposit. The client cancels their event because they broke up, or somebody died, or things happened that they didn't foresee. And as a result of that, they want their money back. So the first thing that you do is you try to avoid court. When that conversation takes place, the first thing I do is I quit referring to it as their money, because it's not their money. It's our money at that point. What they want is their non-refundable deposit to be refunded. But the reason it's non-refundable is to protect the client. That's the purpose of it. Because when they give me that non-refundable deposit, at that point, I have blocked off that date and I'm saying no to everybody else. It's to protect them. We need to be compensated for taking that date off the book. That's the purpose of the deposit. So a couple of things. First, make sure your deposit is a reasonable amount. If you're going to charge $2,000 and you take a $1,500 deposit, that's really not a reasonable amount. I would say 50% is the most you could get away with being considered reasonable. Mine's too low. It has been. I charge a $500 deposit on almost everything we do, and then we collect more, down the road. But let's talk for a second about the word deposit, because it's very common that I see online, you can't call it a deposit because all deposits must be refundable. Simply not true. And again, I can't speak for every state. I can tell you that I've won in court. I won a case for a guy who not only wanted his non-refundable deposit, and it says deposit on it, says non-refundable deposit on my contract. Not only did he want that back, he hadn't even signed the contract yet. And I not only kept the deposit, I sued him for the entire balance when they canceled within the 60 days, and I won. He appealed it, and in California in small claims, the way that works is you go for a whole new trial. It's not just an appeal of the facts. They get a mulligan, they get a do-over. And only the person who's being sued can do that. And he lost again. He lost twice. And I ended up, I gave him an offer. As a matter of fact, at one point, I think I offered to let him out for He had given me $500. I told him that I would write most of it off if he settled it right then for another $1,500 or something along that line. And he told me to go pound sand. And I said, okay, but I'll do that. But in court, I'm going to ask for the full amount that the contract calls for, which was about $3,500, I think. And I won. So I got that. So the deposit, does what you call it make a difference? In California, no matter what you could call it Steve, right? You could call it, this is a brick. It doesn't matter what its name. What matters is how it's characterized and what the parties understand it to be. And my contract is crystal clear that this non-refundable deposit holds a date, and that should it be canceled from them, I will keep that as, it's called mitigated damages, right? So that means that I have some, I'm sorry, I said mitigated, liquidated damages. Mitigation is liquidated damages means to compensate me for what I've already done. That's what that's for. But here's the key. Here's why I win in court and why a lot of people lose. Most of you have a contract that protects you if the client cancels, but it does not protect the client if you cancel, and that's a patently unfair contract. The contract also needs to protect the client. So here's how my contract works. If they give me a non-refundable deposit, if they cancel, and it says for any reasons in giant, bold, all cap letters, right? And then they have to initial that part. If they cancel for any reason, I will keep the entire deposit as liquidated damages. If I am able to rebook a comparable event for their date, then I will return all but $250 of their deposit, which will still be kept as liquidated damages. Because I don't want to keep all of it, but I've already done some work. I've already, once they've done that, they've gotten all of my planning materials. They have value from me already. And so they're not going to get that part back, right? Does that make sense? So now I want to take the, in court, I want to make sure that if that's going to happen, if they cancel, what happens if I cancel? Well, I would never cancel. Yeah, that's what they said too, right? Somewhere along the line, you all hear the stories of the DJs canceling. So my contract says if I cancel for any reason, big bold letters, if I die, right? If somebody very close to my family dies, if we die for any reason, whatever happens, a plane doesn't get me home from a trip on time, then they are entitled to one of two things. Either all of the money back that they've paid me plus an additional $250 as liquidated damages, because they've done some work now and they got to start all over. Their time should be worth something as well. So they get all of that back plus something, or we will give them a substitute MC and it's their choice, right? And if it also says if it happens the day of, it will revert to the, I'm sorry, I said $250, they get back $500 if we use another DJ, which is everything that they paid. We would take $500 off the price of it. When we go to court then, and they portray themselves as this poor victim, then I just said, listen, I understand, I feel really bad for them that happened, but I didn't lose 500. They're out 500, but the contract was for 3,500. I'm out 3,000 because that's what I charge. And if I didn't hold that date for them, I would have booked somebody else and I would have gotten that. I'm out $3,000 even if I keep their 500. They're only out 500. So and by the way, not only am I out that amount of real dollars, I'm out the opportunity to perform in front of people, which is where I generate more business. So it costs me anyway, even if I do that. The other thing that my contract says is this: if they cancel in the last 60 days, they owe 75% of the total balance. And that's in there for one really simple reason. Instead of it being the full amount, it's 75%, because it makes me look very reasonable. And I want to say, look, I did get a day off that has some value, but at this point I've already done most of the work. If they've canceled in the last 60 days, I've done most of the work. So when we get to this point of how much money goes back and forth from everybody, I have to get some value out of all of that. So make yourself the victim. I'm really, I'm empathetic, I'm sympathetic to them, but they got to be sympathetic toward me as well. This is my business, it's my livelihood. And in fact, my cancellation clause says cancellations adversely affect our business. And I won't go into all the wording because I don't want you to use the wording I have so that you'll be mad at me later if you screw it up and say your contract didn't work. Like, my contract works, but you have to be able to argue it in court. And that means being prepared. When I went on this one I was talking about, we didn't even have a signed contract. And I won't get into all the details, it would take forever. And we didn't have a signed contract. We had some reasons for that they hadn't yet signed it. And they were pretty valid. And that was his argument. His big argument was, we don't even have a signed contract. We hadn't even agreed to have him do this yet, except that he had paid the deposit. And there were just a lot of changes that were going in the contract and blah, blah, blah. Anyway, that was his big argument. Contract does not have to be written to be enforced. It just has to be one person giving some money to somebody in consideration for something else, and everybody has to understand what's being given. And when we went to court, we won on that very simply. So you go to court. Let me sum this up for you really quick. You go to court, be the victim, be prepared, really, really prepared, as much as you would be prepared for their wedding. Be that much prepared for court. Be sympathetic. Be very reasonable. If I went in, and with the same case I was just talking about, if I had gone into that and said, so I want all of the money for it, at some point the judge would have been able to say, wait a minute, but you didn't do all the work. You did some of the work, but you want to be paid for all of the work. So now he sees me as an unreasonable person. But now I can say I've done most of the work, because most of the hours are done before the day of the wedding, and then I still have those hours left, and I do get some time off, but it's really what it's costing me. So we're way over our minute this week, but it's a complex subject. But don't worry about whether you call it a deposit or not. Check with your attorneys. You can do that. Make sure it says non-refundable. And if you ever get a call, I'd like to get my money back, then you have to say, well, listen, the reason that the non-refundable deposit is non-refundable is because, and then you know how to explain that. Yeah, but so you're not going to give me back any of my money? Well, you don't actually have any money. What you did is you paid a non-refundable deposit. And so you're asking me to pay a non-refundable deposit. And again, if you can have this in a conversation, generally you can clear it up. Because you can just say, well, listen, what did you think was the point of the non-refundable deposit? What did you think I would do as a result of that? Because my understanding was I was now committed only to you, to nobody else. So if anybody called, somebody could have called and offered me a $12,000 party, and I'd have to say, sorry, I can't do it. I'm already booked that date. Is that your thought, that I was going to do? Because what if I had called you and said, you know what, something came up, I just don't want to be your DJ anymore. Would that be okay? No, you'd expect something in return. That's why our contract says if I do that, I'm going to give you back all the money that you've paid and more, and now you have to do the same for me. All right, hope that helps you. But listen, do a great job, and you'll stay out of court from the events. And then when the people cancel, make sure they understand when they're signing, no matter what, you can do that. They can always buy event insurance if they're worried about it. Talk to you later.